Hello, everybody. Welcome, welcome. My name is Pam Esquire, and I am the Law Intellect. Welcome, welcome, welcome to everyone that is catching this on the replay. Everybody's been inboxing me like, "Where are you, ma'am? Where are you? I've been working." But I missed you guys too, and I'm glad that you love the content. If you love the content, please subscribe, like, and share. Thank you to everyone that's been waiting since I posted and said I was coming on. See, this is what makes me come on when I say at 7 in the morning, let me go put a post up and say that I'm coming on at 2 o'clock. I'm a little bit early, but I'm here. Hey, CBBJ, how are you? Taylor Clarence, how are you? Rita, what up, though? I'm patiently waiting. I thank you guys. I've had people sending me stuff like, you ain't talk about this, you didn't talk about that. There's so much we can talk about. And I'm going to get through as much as I can. Rita Walker, hello. Lindsay, hello. Lynn, hello. Davita, hello. BB, hello. Patrick, thank you for stopping by. Sweet Nectar, thank you for coming by. Simply Sean, good afternoon. Thank you, thank you, thank you. Hey, Poetic Mouth, to all my mods, shout out. Thank you so much. Danielle, hey, hey. Patricia Dwight, hey. LaFrance, good to see you. Shelly, Sanita, Angie, all y'all, thank you so much for coming on here. We got a few updates. Hey, Cocaine, girl. We got a few updates today. The last time, believe it or not, I really didn't even cover everything on Whitehead. But I just got tired of talking about him for a minute, so I had to take a little bit of a break. So we're going to talk about him, and we're probably not going to talk about everything. I'm probably going to have to do a whole nother video because I do have a 2 o'clock. That's why I came on earlier than what I said that I was. Thank you to all 85 of you that's on here. Immediately, you've been on it. If you could hit that like, and if you have not subscribed, please subscribe, please, because I want you to be able to, engage in the conversation. Because I got it on subscribers only. Y'all not gonna just be coming over here all up in the chat, raising my blood pressure up, and then you not even subscribed to the channel. I mean, goodness. At least if I'm gonna raise my blood pressure, y'all should be subscribed to the channel. That's all I'm saying. What up, though? That's the Detroit thing. Yes, I have followed his trial. I actually was gonna go live yesterday for the verdict, but since we hadn't been following it, that judge has the patience of Job, because that trial was a whole entire clown circus of a show. Hey, Carolyn, Denise. Well, let's get right into it. Y'all seem like y'all miss me. I miss you guys too. We're gonna talk about we'll talk about this lady right here. This is Lashunda Ellison. If you guys recall from the previous video that I've had, she is the wife of, what is his name? I know he goes by Mac Ellison, who was killed because a stray bullet went through their window of their home. Well, not the window. It went through the house somehow and then went through the headboard. But go back on that video and you can see we did a couple of videos or whatnot regarding him, and some of the Facebook lives that he did. We went over that as well. Well, we have an article that came out where they are offering a $10,000 reward for whoever did it. And then we have, well, we'll get to that in a minute. Let's go over this article because we're gonna be on Whitehead for a little minute. So you guys stay with me. Stay with me, please. Okay. Family offers $10,000 reward to solve case of Georgia pastor's wife killed by stray bullet. Calls on Governor Kemp for tighter gun restrictions. That's the article. So let's go over this article right quick. A Georgia pastor whose wife was killed after a stray bullet entered their home said he is working with authorities to offer a $10,000 reward for tips that lead to an arrest. Lashunda Heath Ellison's family held a funeral for the mother and hairstylist in Atlanta on October 18th. That was last week, nearly 2 weeks after her husband, Pastor Herman Mack Ellison, woke up to her breathing heavy, lying atop a bloody pillow. Ellison told his congregation on Sunday he now sleeps in his wife's spot on the bed to feel close to her. Quote, it's still hard to believe that seat won't be occupied again, referring to the First Lady's seat in the Temple of Faith Ministries in Atlanta. Authorities believe Heath Ellison's death was the result of random gunfire that penetrated the family's wall in the Decatur home. The pastor said DeKalb County police discovered a hole in the back of the house, apparently from a bullet that went through the married couple's headboard as they slept that night. No one in the home heard the gunfire. Doctors told Heath Ellison's family that the bullet was lodged in the center of her brain. She died days later. Quote, my mama always said a bullet doesn't have a name. It can go anywhere it chooses, the couple's daughter, Taylor Ellison, told Fox 5. The DeKalb County Police Department has opened a homicide investigation into the case and is searching for leads for a possible suspect. The grieving family believes Georgia's gun laws are to blame for the tragedy. This could have been avoided. A lot of things could have been avoided. This has happened too many times where somebody's hit by a stray bullet or somebody's hit intentionally, the couple's son, DeJuan Ellison, said. Georgia Governor Brian Kemp signed a bill into law in April that loosened gun control, allowing gun owners to carry a concealed handgun in public without a license from the state. The pastor said the couple keeps guns in their home, but Heath Ellison's family said the state needs more restrictions. About 70% of Georgians surveyed by the Atlanta Journal-Constitution said they oppose permitless carry. The laws of guns, they have no change. They have to change. I'm sorry. I don't know what the system has to do. I don't know what the governor has to do. Taylor Ellison said, Governor Kemp, I don't know what you have to do, but it's getting out of control. So essentially, they're offering a $10,000 reward. Somehow they're blaming this on gun laws, although, from my understanding, they believe it was just a random shooting in the background. Like they have a forest area in the back, so maybe somebody was randomly shooting. So the way it's being described sounds more of a reckless discharge of a firearm than an actual homicide, like I chose, intentionally tried to kill somebody. What the gun laws have to do with that? I don't know. I don't have an answer. Do you guys have an answer? I, but let's go look at the I have the incident report because we already looked at the video. So I want you guys to remember what Mr. Ellison said occurred in his car ride video from the previous video we had that everybody was like, "Oh my gosh, I didn't know this was going to trigger me like this." So now we have an incident report. Let's see here. You said it just sounds good. I just was wondering if I was missing something. I'm like, what does this have to do with gun laws again? And I'm no governor, Kemp fan over there. I hope our girl Abrams takes it. But anywho, so we have the DeKalb County Police Department incident report. Exactly. That's why I said to me the way these facts are being presented, it sounds more like a reckless discharge of a firearm. It doesn't sound like, like in law school, they give you a scenario of somebody going to a crowd of people and they just shoot up in the air, and you're not really trying to hit anybody, but because you're being reckless because there's a potential that that could occur. Hey, gotta blame some. Okay, so October 4th, 2022 at approximately 3:27 a.m., I responded to, it has the address in reference to a person shot. Prior to my arrival, the victim, Miss Lashunda Ellison, was transported by AMR North Medical 48 to Grady Hospital. Per Grady Hospital medical staff, it was stated Miss Lashunda suffered a gunshot to the head. Upon my arrival to the incident location, I observed a hole in the rear of the house on the second floor. And see, I was wondering because in the video, remember, Mr. Ellison or Pastor Ellison mentioned the arms hanging on the side and how he was looking at how her arms were falling as they were going down the stairs. But I was like, well, it could be that they were going down the stairs of the front, the front steps or something. But I was wondering if it was on the second floor. I'm like, the second floor? It says the second floor on here. Okay. Upon my entry to the incident location, I observed a bullet hole on the headboard of the bed that was against the exterior facing wall. I met Mr. Herman Ellison, the husband, who advised he woke up to his wife, Miss Lashunda Ellison, snoring, and he began to shake her to stop her from snoring. Mr. Herman Ellison further advised he noticed that Miss Lashunda Ellison's head was laying in a pool of blood. This caused Mr. Herman Ellison to wake up his two children. So he's saying in this, he went to wake her up and noticed she was in a pool of blood. And then after he noticed she was in a pool of blood, he called his kids. So y'all remember, this is what the incident report is saying, which was written immediately after. Mr. DeJuan Ellison and Miss Taylor Ellison, who were also present in the house, to call 911 for medical attention. While on scene, I did not observe any shell casings in the immediate area of the residence. Homicide, assault detective, and it has his name, and crime scene investigator, their name, further investigated, and it was turned over to them. So let me show you guys something right quick. And this is why I was saying, and that's not saying that one way or another. This is why attorneys tell you don't talk. The reason why they tell you don't talk, because sometimes you're talking out of emotion. Sometimes you will omit important facts. Sometimes it looks like you're trying to give information because you think you're slicker than them on how, this is how the police observe you. The police look at you like you're guilty until proven innocent. In the court of law, you're innocent until proven guilty. But when you go to the police, that's why they put it out there. This is what I don't like about shows like First 48 Hours. We'll get them to come in here and then they'll tell the camera he lawyered up. So we don't know why he lawyered up. He must be hiding something. No, you're protecting yourself because your adrenaline is going, your memory is all over the place. It could be several reasons, but the safest thing that you can do is to get a lawyer so that you don't make statements, because I was reading that and I automatically remember contradictions. Not that they may be significant, but it's the point of you may have some contradictions if you just start talking. So, let's go back to this video real quick. This was the video of the car ride.
I jumped up out the bed and And I kind of got choked up a few minutes ago because I was dreading to tell this story. I jumped up out the bed and I turned the light on. And when I saw my wife, her eyes I could barely see the white. And I figured I could push her out of what she was in. And I was saying, Shell, wake up, wake up. And at the same time, when I couldn't wake her up, I started calling my kids. Taylor, DeWan, please come and help. And I didn't realize I did all of that because I was in the moment, and my son told me the other day, he said, Daddy, that's all I keep hearing. But I want to tell God thank you because my son, for the first 2 or 3 nights, he did not come home. He stayed at home last night. And that's all I wanted was my family to be with me. And let me get back on track. It's a lot, y'all. I'm surprised I'm not traumatized. All the kids arrive in the room. I don't know who called the ambulance first, my son, myself, or my daughter. But I know I was on the phone with them and they was asking me 1,000 questions. And Taylor said, Daddy, let's roll Mama over so she can breathe. And when we rolled Mama over so she can breathe, we saw that the back of her pillow was full of blood. But looking at her, we didn't see any blood. And we told the paramedics that she was bleeding.
So again, now you saw the blood, then you wait, then when the kids came, you rolled over and that's when you noticed the blood. You have the kids calling EMS, or you told them to go ahead and call them, but now you were on the phone with them and they was on the phone. You see what I'm saying? And it may be, that's not to say what's true or not true. It could be you're in the moment. This is why I say that. Because some of us can really, like, if we're following it, because and this is another thing. I'm about to show you something else. Give me 1 second. So this is what his son put up. I guess he doesn't like the fact that people are talking about this case. So this is what he said. I guess he told us to mind our business. This was his mind your business public, even though we brought it to the public, mind your business because I don't like what you're saying. So he says, excuse my language, but all y'all weird, blank, fake FBI agents posting my dad's video and making up their own assumptions about my family situation and what y'all think happened is crazy. All y'all fake, blank conspiracy theorists needs to relax and speak when spoken to. He told us, he said, speak when spoken to. But the thing is, we were spoken to, and you just offered a $10,000 reward. So you asking people to help figure out and to help find who could have done it. Okay. Y'all can send the hate to me, matter of fact, because I'll clear your stupid blank out. Y'all quit to say somebody's suspect when y'all the ones taking the time out your day to screen record multiple videos on a delicate topic to go viral and cause a stir. A family is grieving, and instead of praying for us, thousands of people are saying dumb, blank, trying to sound intelligent, and that goes for the same people agreeing and feeding into it. Why do people do that? Why do you go, you talk about it on your Facebook, you talk about it on YouTube, you talk about it on Instagram, They did this article and a couple of videos for the news the next day after the funeral. They did a whole sit down. When you go to the media or you go to the public, you cannot control how the public perceives. I know in our mind we want them to think like we think, but the public doesn't think like you think. So if you choose to go to the public, hey, I can be beneficial because I see if I went, scroll by to see what was going on. His Facebook page and changed a little bit. That video I just showed is no longer on his Facebook page because obviously you took heed to somebody saying this ain't looking good with you with this video. Now there's more videos of the good times with his wife, like her birthday and all the happy times that they've had and whatnot. That's what it's being flooded with. But yeah, his son tried to tell us off, okay? He told us to mind our business. You know what? We really don't know what happened, and that's definitely not my intent. Y'all know me. I'm like I try to be neutral, and I try to get everybody else to think neutral. This is what I have to do. I have to persuade juries to look at things in a different manner when I did defense work, because obviously the prosecution got way more than what we got. So I want people to look in. I just want people to know how it works. You know what I'm saying? Like, don't think, oh, they are everybody's empathizing because of this is what happened to my wife. The police gotta do their job. So just be careful and be mindful. That's all I'm saying. That's all I was trying to say. That's it. You said, well, when you put your business out there, people are going to form an opinion. That's what happens. You can't be a limited purpose person where a limited purpose, like they say, public figure. When you throw yourself out there, yes, the news probably would have had the information. But I've had cases, and my husband is on here, and he can tell you, I've had cases that have been newsworthy where they've contacted me. They've been to my clients' homes, they've inboxed me, and I don't give them anything. All they can do is report on what my pleading is, like what I do on here sometimes, because I don't give them a statement because my client is still going through this. So what I'm gonna talk to you for? And then after that day, it's done. But the more you thrust yourself into the limelight, the more people start digging into you, more people start digging into what happened, what the situation is, and then you get mad at us. Like, what you get mad at us for? So you want to know my view. So that's that story. Thank you so much for the Cash App, Rita Walker. I appreciate it. Thank you, thank you, thank you. So that's that. And we're going to keep following the story. Sorry. We're going to keep on following it because it's interesting. And we want to know how a bullet got to the second floor. It centered through the head, center wise, through the headboard. Nobody heard the gunshots. We just want to know. Did they climb in trees? Is there some snipers out there? Like, we want to know what's going on. That's it. Okay. Thank you so much, Rita. So before we go on to Whitehead, somebody asked me, I done took it down. I'm sorry. You asked me about Daryl Brooks. If anybody has been following the Daryl Brooks trial, that was the guy who, I believe it was in Wisconsin around the holidays, plowed through. I think he was trying to like run his girlfriend over, and he ran over some people and killed them and injured a whole bunch of people. And he represented himself. That trial was such a clown show. I would try to watch it in certain, like, I could watch it for so long. I think it's horrible. We do have a right to represent ourselves, but I think it sucks that they're allowed to cross-examine the victim. That you are the one that traumatized, and now you get on the stand and you get to consistently like badger them. I just think that's a hole in our system. I think that's very traumatized. Yes, you have the right to represent yourself, but I think they should have had required him to have an attorney next to him or something. That's typically what they do. I don't know what this clown show was. And then the judge, I get it. She was trying not to be appealed. So I think that's why she took as much as she took in that trial, but she was just way too passive for me. I mean, it's cool to be patient, to cover yourself and cover your bases, but he was just doing too much. At first, I'm like, oh, he has to be a head case. Then after a while, it was like, you know what? He doing this on purpose. He's just prolonging the inevitable. He knew he was gonna get convicted of all those charges. He knew it. So we just got to watch the craziest yet. I couldn't imagine. The prosecutors was probably frustrated because this is wasting their time. That means the trial was longer than it needed to be because of how he was acting. Daryl Brooks had to leave out of the courtroom several times. He had to be adjacent to the courtroom. He kept talking about you don't have subject matter jurisdiction over my case. I mean, he was just, because I guess he was trying to say sovereign, he was a sovereign person or whatever his argument was as to why she didn't have jurisdiction. It was just crazy. I don't have any other word to say, but he was crazy. Does anybody else have any thoughts on Daryl Brooks? Ooh, I gotta catch up on my you didn't watch, but you heard about it. He lost because of his conformations with the judge. Do you mean confrontations? He was so disrespectful. She let him clown too, and he knew it. Yes. I watched most of it. He had an attorney he fired. I'm pretty sure he's uncontrollable, but it still should have been somebody, I guess. It's somebody out there he respects, I would hope. I would have sat next to him though. He might have got kicked and pinched a few times, but the Brooks guy knew he had it coming. The judge stood firm. Now, I did read that Edison's father died mysteriously around the same time as his wife, but different year. I haven't researched it. Girl, let me know when you get the information, Cocaine. Wow. Nope, I know what you're talking about, Ellison. We felt so bad for the victim's family. I did as well. Thank you. I'm glad you guys are where I feel so loved. Thank you so much. Thank you for the Cash App. Let's see. Shawana, thank you so much, and I love you back. Okay, y'all ready for Whitehead? So we got to do a background real quick, not too much. So in our last video, we talked about Whitehead suing his attorney. Whitehead's not his attorney, I'm sorry. Whitehead suing Anderson's attorney. Let me pull that up right quick. So Whitehead sued Anderson's attorney, as you see. That's Peter Manuel Rivera and the law firm. And his rationale for suing him was, he said on September 21st of 2022, defendant communicated with plaintiff directly via a FedEx mailing. So basically, this attorney sent Whitehead directly some documents from the court instead of sending it to his attorney. That's what's being alleged anywhere. Now, there was disagreement on whether the attorney ever entered an appearance for Whitehead and just entered it for his company, but we'll talk about that in a minute. Plaintiff's motion to dismiss was filed in the Anderson case by Mr. Ponder on September 15th. Plaintiff's motion to dismiss notified the defendants that the plaintiff was represented. So on, like I said, September 21st, defendants communicated with plaintiff directly via a FedEx mailing. On September 22nd of 2022, plaintiff received a FedEx mailing from defendants on the Anderson matter. Defendants breached their duty not to communicate with plaintiff about the Anderson matter. Defendant said duty arose under Rule 4.2a of the New York Rules of Professional Conduct. Defendant's conduct proximately damaged plaintiff to incur fees, costs, and emotional distress. Wherefore, plaintiff demands a jury trial and entry of judgment in favor of plaintiff and against defendant for compensatory damages and $1 million in punitive damages. Yes, you heard it, $1 million, because this attorney contacted him via FedEx. So, of course, the attorney filed a motion to dismiss because this sounded crazy. Let me see something right quick. There was a letter that was sent to Whitehead's attorney first before this motion was filed. Let me see if I have that. Bear with me, people. I have so much paperwork. Okay. Yeah, we have it. So, this was the letter after this attorney, because I wondered, I'm like, what did this attorney feel like when he got this? Because I'm like, what? Is this serious? No, he was serious. So the attorney sent him a letter and said, I write you on behalf of Richter Restbro PLLC and myself in response to the filing by you of the initiating pleading in the above referenced matter. You are hereby advised that your filing of this pleading constitutes frivolous conduct under Part 130-1.1 sub C of the rules of the Chief Administrative Judge of the New York State Unified Court System, in that it is completely without merit and cannot be supported by any reasonable argument for a modification or reversal of existing law. Subpart 2, it is primarily taken to harass or maliciously injure me and my firm. And subpart 3, it asserts material factual statements that are false, including but not limited to that your client, Lamar Whitehead, suffered damages due to service upon him of a FedEx mailing in another matter. Moreover, your pleading states no actionable claim or cause of action under any cognizable legal theory for the relief sought. This action is vexatious in nature and seeks only to distract from the litigation between our client, Pauline Anderson, against your client. And it has case law. Accordingly, we hereby demand that you and your client withdraw and discontinue this matter with prejudice by no later than Tuesday, October 4th, 2022. Be further advised that should you defy the foregoing demand and allow this matter to continue, we will have no choice but to seek sanctions imposed against you and your client to the maximum extent allowed by law, as well as costs, expenses, and reasonable attorney fees arising from same. An attorney who has been forewarned of the dubious nature of this frivolous action and yet continues to pursue it may be sanctioned to the maximum limit provided by law, and it has case law. I recommend that you govern yourself accordingly. That sounded like church, right? Govern yourself accordingly. So y'all know Whitehead attorney responded. He wasn't just gonna let that fly. Y'all ready for this? Say aye. Say aye if you want to hear the response to this letter. Okay. All right, we got some eyes in the building. Okay, so his attorney responded. I don't even want to show his name. So his respondent said, I write in response to your letter dated September 30th, 2022. Pursuant to our conversation by phone on today, the pending litigation will not be withdrawn. When I asked you what allegations were frivolous, you indicated that they all are in general. However, you were unable to dispute any allegation or support your frivolous conduct claims. For clarification, Bishop Whitehead, in fact, states a cognizable claim for negligence in this case. To establish, did he say negligence? Okay. To establish a common law claim for negligence, a plaintiff must demonstrate one, a duty owed to the defendant, by the defendant to the plaintiff. 3, breach of that duty. And 4, the breach of that duty constituted approximate cause of the injury. And it has case law. I advise you that this is a negligence case. In response, you indicate you have no duty to my client, Bishop Whitehead, or to me. Further, you said that you have a duty to the law. The law imposes duties to others, e.g. plaintiff. Here, your duties to Bishop Whitehead includes those imposed under Rule 4.2a of the NYRPC. You breached your duty under Rule 4.2 by communicating directly with my client on September 22nd. Your breach was the proximate cause of my client incurring additional costs, fees, and distress. Consequently, my client has an actionable, valid negligence claim against you and your law firm. Hopefully, this helps you understand the nature of the claims against you and your law firm. Note, just because you claim a defense to any element of the claim does not make this frivolous. The law allows for a person allegedly wrong under the law the opportunity to be heard in court. Should you have any questions or want to discuss a resolution to this matter, contact me at any time. Okay, let me start. Okay, wait a minute. So, let me see these comments right quick. And then I'm gonna go on to what the response was because they obviously couldn't withdraw it. As you see, his attorney said, heck no, I won't go. We are going to pursue this claim against his attorney for sending his FedEx package because my client, Bishop Whitehead, has suffered distress and additional cost by receiving a packet, a courtesy copy of a pleading in the mail. So let's go over this brief. This is what's going to take the majority of the time because I find this brief quite interesting. So he has all this table of contents. All of this is required when you submit briefs to most courts. So he has his preliminary statements. Peter Manuel Rivera and Richter Rest Pro PLLC submit the within memorandum of law in support of their motion pursuant to blah blah to dismiss plaintiff's complaint with prejudice and pursuant to blah blah seeking the award of cost and monetary sanctions against plaintiff and or his counsel. Plaintiff's lawsuit alleges no recognizable cause of action against the defendants. Any reasonable arbiter would determine that this action is frivolous, that it is beneath the dignity of this court, and that it should be dismissed at the earliest possible juncture. In short, plaintiff Lamar Whitehead alleges that he is entitled to compensatory damages and $1 million in punitive damages by virtue of the fact that in a separate underlying litigation in which defendants are representing a client who is suing him, defendants caused a courtesy copy of a notice of an impending emergency application for a temporary restraining order to be sent via Federal Express to Mr. Whitehead. In addition to his attorney, it bears repeating, plaintiff and his counsel intend to argue in court that because defendants sent Mr. Whitehead a courtesy copy of TRO notice, he put that in bold, related to ongoing litigation, A notice which was also conspicuously sent to Mr. Whitehead's attorney. Defendants breached an amorphous duty of care to their opposing party, and that this alleged breach of duty caused Mr. Whitehead to allegedly incurred over $1 million in damages. Plaintiff's position purportedly substantiating this lawsuit are completely frivolous. The submission of a courtesy copy of the TRO notice is absolutely not a quote communication to a represented party, which could reasonably be contemplated by Rule 4.2a of the New York Rules of Professional Conduct. Furthermore, even assuming arguendo such a notice could be deemed such a violative communication, the fact of sending such a notice to an opposing party in no way gives rise to an actionable claim against defendant. New York law is crystal clear that to be liable in tort under any theory of negligence, an individual or entity must owe a duty of care or other fiduciary duty to the plaintiff. No such duty existed between defendants and Mr. Whitehead, and accordingly, no such duty could be breached. Furthermore, even if such a duty between a party and the opposing counsel existed, which is clearly it does not, and even assuming a violation of New York ethical rule transpired, which again, it does not, such a violation would not give rise to any private right of action which could serve as the basis for this lawsuit. So what he's saying is when we have the rules of statutes have to specifically tell you that you have the ability to sue. So all of us have to pass what's called character and fitness, and we have to say we're going to abide by the rules of professional responsibility within our states. The rule that he's saying that Whitehead's attorney is claiming that was violated was in their rules of professional responsibility. What his attorney is saying, there is no cause of action. Usually, if you breach a rule of responsibility or it's to that level, then your state bar handles that. That's not a cause of action really for somebody to come after you, unless you're claiming like legal malpractice or something like that. But that would be you and your client because you've done something with your client. So you have to have within those statutes and within those laws an ability and a right to sue. Everything you don't have the right to sue, they don't recognize it under law. So he's saying your client doesn't have a right to sue based on me sending him a package, regardless, even if it is a violation of rules of professional responsibility. He said the filing of this action is a clear abuse of process, which is directly contemplated by 22 NYCRR section 130.1-1. In response to this frivolous and harassing lawsuit, defendants approach plaintiff's counsel with good faith, demand that the action be discontinued. Despite defendants' good faith request, that's the letters I just read, which was based on Hornbook tort principles, which clearly require that there is no basis for a finding of liability against defendants. Plaintiff's counsel refused to discontinue the action. Accordingly, defendants are forced to defend this lawsuit and file the within motion at great time and expense. As such, defendants are left with no choice but to further request the imposition of cost and monetary sanctions against plaintiff and or his counsel pursuant to blah, 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 and an amount to be determined by this court up to the statutory limit, plus defendant's costs, expenses, and reasonable attorney fees incurred for defending this action. So what y'all think? So that's like the summary of it, and then it gets into the law, the procedural history, because all of this is a separate lawsuit, but it's all connected to the Anderson matter because apparently he sent the TRO, like he said, he sent a courtesy copy to his directly to Whitehead's home. What y'all think? Shaking your head. You gotta be in line to make $1 million to lose $1 million. They're saying punitive damages, so they want $1 million to be the punishment. Punitive damages are punishment, so they want the $1 million to be punishment for him sending that. They said compensatory damages, that should be more of a some certain. But they didn't put no amount there. They just put that it should be the punishable amount should be $1 million. Run him his coins. That's a waste of the court's time. But hey, he gonna pay one way or the other. Why is he acting this pastor as he's not traumatized for waking up? You're behind on video, okay? Probably because Whitehead keeps saying he didn't know anything or received anything. He says that on every case. He'll say he never was served. He never got, I think he's desperate and knows he's about to go down. He's not going down without a fight. He's fighting. He's fighting. Because he's like suing a lot of, well, not a lot, but he's suing a few people, trying to get his stuff together, I guess, trying to say people are saying that he owe money that he doesn't owe. And he done found an attorney willing to do that. So how does he do this stuff and call himself a man of God? Once again, they denied receiving it before the lawsuit. And also, let me go back to this. We'll read a little bit more and then we'll go into something else. So he says the defendant cannot be liable in tort because they owe no duty to plaintiff. In New York, one cannot breach a duty when there is no duty owed. There's the case law. Then it tells you to prove a prima facie case of negligence, the plaintiff must establish the existence of a duty on the defendant's part to the plaintiff and that the breach of duty was a proximate cause of the injury to the plaintiff. Absent a duty of care to the person injured, a party cannot be held liable in negligence. So he's basically saying he doesn't have a duty. No further analysis is necessary to require dismissal of this matter, as it is quite clear that defendants owe no duty to plaintiff and cannot be found liable. The previous notwithstanding is the unlikely event that this court determines that defendants owe the duty to Mr. Whitehead. The mere fact of serving a courtesy copy of defendant's TRO does not create a private cause of action against defendants. Defendants did not violate 4.2a of the New York Rules of Professional Conduct. And even if they did, such a violation cannot serve as a basis for a private cause of action, which is what we just talked about. Then he goes through the professional conduct rule, which is what we just talked about. Let me see what his conclusion is. Okay. Defendants herein are entitled to an award of costs and the imposition of monetary sanctions against Mr. Whitehead and or his attorney as recompense for the time. See, recompense, he must be saved because he using all these words in the Bible. Recompense for the time and resources spent defending against this frivolous action. The rules of the chief admin judge provides in relevant part, quote, and this for all the people that ask about people can file anything or whatever. Yeah, they can file anything, but they do have rules that you may get sanctioned for it. And this is one of them in New York. The court, in its discretion, may award to any party or attorney in any civil action or proceeding before the court, except where prohibited by law, costs in the form of reimbursement for actual expenses reasonably incurred and reasonable attorney fees resulting from frivolous conduct as defined in this part. The court is as appropriate may make such award of cost or impose such financial sanctions against either an attorney or a party to the litigation or against both. It says conduct is frivolous if one, it is completely without merit in law, cannot be supported by reasonable argument for an extension, modification, reversal of existing law. It is undertaken primarily to delay or prolong the resolution of the litigation, or to harass or maliciously injure another, or 3, it asserts material factual statements that were false. An award of cost or the imposition of sanctions may be made either upon motion or upon the court's own initiative. So he says defendants request that in making this determination, the court look at the entirety of the circumstance surrounding plaintiff's complaint, Plaintiff and his attorney are suing an opposing counsel in an ongoing litigation for an amount in excess of $1 million on the basis that during the midst of the underlying action, defendants conspicuously sent plaintiff a Federal Express envelope which contained a one-page courtesy copy of the same TRO notice, which was also sent to his lawyer. Plaintiff's complaint in risible fashion alleges that the mere receipt of the TRO notice caused him to incur fees, costs, and emphasize emotional distress. As is stated, supra. This action, supra means above. This action is completely unserious and vexatious, and there is no world in which this court could find liability against defendants under unambiguous New York Hornbook law. Simply put, even giving plaintiff the benefit of the doubt and assuming defendant somehow violated Rule 4.2a, there is no colorable argument that such alleged violation could give rise to a private right of action against an opposing counsel. The action is completely without merit in law and cannot be supported by a reasonable argument for an extension, modification, or reversal of existing law. Furthermore, given the frivolity of the lawsuit, which was filed in the face of all known jurisprudence, the only plausible explanation is that it was filed simply as a measure to harass defendants, perhaps with the goal of frustrating the progress of the underlying action. Immediately following plaintiff's filing the complaint on September 30th, Peter Riviera Esquire, on behalf of defendants, contacted plaintiff's counsel with a good faith demand. We read that. By filing this frivolous lawsuit and then refusing to discontinue same, plaintiff caused an entirely predictable outcome. Defendants have been harassed into being required to defend this case at great inconvenience and at substantial cost, including but not limited to a potential increase in defendants' insurance premiums with their reputation. Oh, I didn't even think about that. Every time you're sued, you do have to notify your malpractice insurance. Ooh. Ouch. With their reputation already having been maliciously injured by virtue of the fact that such a frivolous lawsuit was filed on the public record. Yeah, because we're talking about it. Definitely is public. Accordingly, defendants request pursuant to 22 NYCRR that they be awarded costs and that the court impose monetary sanctions against plaintiff and or his counsel and an amount to be determined by this court up to the statutory limit, plus defendant's costs, expenses, reasonable attorney fees incurred defending this action. It is respectfully submitted that the type of behavior exhibited in this matter, including the malicious filing of the frivolous lawsuit and the unreasonable refusal to discontinue same, warrants appropriately sufficiently high monetary sanctions in order to deter plaintiff and his counsel from engaging in similar course of abusive process in the future. So what y'all think? What do you think the court should rule on this? You've heard both sides. He's saying it's frivolous. Whitehead's attorney basically said it's negligence and it's worth $1 million. If you are the judge, you guys are the jury. We'll do a bench trial. You guys are the judge. What would you guys rule in this case? You said his voice get on your nerve. Oh no. You said they're wasting the court's time and money. It's definitely that was an interesting move that was done filing this case. It was all about him, total disregard for the victims and their family. Okay. Some of y'all, I know you coming in late, so I'm trying not to hit the ones from the first story on the Ellisons. He said, for law interest said, throw it out, dismiss it with prejudice, huh? Frivolous and wasting the court's time. Throw it out. Well, we'll see what I'm sure his attorney has a response, and we kind of know what it is based on the letter. So we'll see soon. TD said dismiss it. Oh, thank you. I'm glad that you came over here. You said sanction Whitehead and his attorney. Tiffany said you said get out of here, and then you hit the gavel. Case dismissed. Well, in other news, and I wasn't really going to report this because I promise you, I don't even know if Whitehead even knows because it doesn't look like he's been served. But we do know that yesterday, and I don't know what happened in that case, but I don't think it matters at this point because in the Anderson case, they were trying to, if you look at the previous video, y'all, if you guys just got on here, new subscribers, hey to everybody, you have to follow the other video, at least the one before to know what I'm talking about here. But Anderson, who is has a lawsuit against Whitehead alleging $90,000 was taken from her under fraud and all these different claims. Those are in a previous video a while ago. But there was a hearing yesterday because he was trying to, I guess, get an attachment to Whitehead's home because he heard and saw, like we did, that it was up for sale. So, as most of you guys already know, because you guys have inboxed me, but I knew this like a week before, but I knew like the day it was filed. So I was like, he probably doesn't even, he may not even, I mean, he knows if he paid his mortgage or not, but because I didn't see where he was served, I didn't really talk about it. What? Their request may not matter at this point because unfortunately, it looks like unless unless he comes up on his payments, we have a foreclosure complaint. So them trying to attach it, remember he was trying to sell it before. According to this document, there are other liens as well. And yeah, that might not even be an option. And they say the defendants failed to pay the monthly payment on November 1st, 2019, and all payments thereafter, resulting in default 30 days after the date of the first missed payment, and said payments have remained unpaid. As a result of said default, plaintiff hereby elects and declares that the whole unpaid principal sum due on the note and mortgage, along with all unpaid interest, advances, fees, and costs, shall be accelerated and is now due and payable. So there may be nothing to attach unless he comes up on this, payments, which he can. He can always get himself out, like we were talking about yesterday was Kim Zolciak and her house going into foreclosure. You can always, come up on your payments. But there were other liens that were mentioned on here. Y'all, y'all asking me questions. I can't answer these questions. How you keep getting loans? I don't know. So I was trying to find something. I must not have pulled it out. I don't want to show like way too much information. But yeah. So that occurred on the 18th. So when the hearing was yesterday, and that's what they were trying to do, I was like, well, it's really nothing you can, because there were other outstanding debts that I think people were trying to put on there. That's why there were other defendants on that complaint, because you have to satisfy all liens. So that's what it's looking like. What y'all think? You say he think he's Donald Trump. Does that mean the other attorney can sue Whitehead because it's frivolous? No, I think what he's doing now is the appropriate remedy is to respond and say it's frivolous and then ask for cost and attorney fees. I think what he's doing now is what's appropriate to do. That's what the documents say. I don't know if he paid. Just to let everybody know, this is just the document. It's this is what they're alleging. So this is alleged. It has not been. Well, they attack documents as their proof, but I don't know what's true or false. You know, I'm just reporting what was filed. That's for the residents. Good afternoon to you, Raymel. Good seeing you too. I saw that. Somebody in where is that at? Connecticut. Somebody in Connecticut told me they do have wood stairs as fire escapes. I hadn't heard of it either, but apparently they do. So he does he is working on his building, you know. Does look like he's trying to work on his building and get it up to whatever code. Does the paperwork state how much he owes? Well, you can kind of guess how much he owes because it tells you how much the monthly payment is, and then when was the last payment according to them, and it would be a significant amount because he lives in a what is it, almost a $2 million home, 1.6, $1.7 million home is what he purchased it for, I believe. Yes, if you guys would like to donate for all of this hard work that I'm doing, let me know. That's my cash app. You say he's probably working on it so he can sell it. Yeah, that would be the smartest thing to do. Work on it so that you can sell it. He probably was able to stack a couple dollars. But I doubt that they're gonna allow anybody else to attach anything to that property. Because they do offer you that. Like they'll offer for you to hand the keys over or they'll offer you to try to sell it. I think that might be why he was, opted to sell it when everybody was like, wait a minute, he's selling his property. I think the real estate insider posted his home and said that he was selling. You know, he might have to move in one of those apartments. He needs to fix the buildings up. What about the cars and clothes and shoes? What about him, Royal 12366? Oh man. Any news on the robbery? So they have a hearing tomorrow. However, yesterday, Mr. Anderson attorney did request that the judge allow him. This was very interesting to me. So he's on house arrest. This is the one that's out for the robbery. So he's on house arrest. And let me see if I got the document. So apparently, I got so many paperwork. It's crazy. Let me see. So apparently he is trying to take a test for a job. And so it asked the court, can he have a day where he can take the testing so that he can become, I guess, work for the city or something, the New York City Department of Sanitation on October 31st. So he's on house arrest right now, but what he's trying to do is to get out. So he only can go like to the courthouse and all of that. So I guess he wants an expansion so he can take this test. He signed up for it 3 months ago And I guess they're saying he doesn't have a record and he will report after he takes this test. Is the gist. I'm just summarizing the letter. So he's requesting that he be allowed to take this test so that he can make some money while he's going through this whole ordeal. So there was a status conference that is scheduled for tomorrow. There was also one in December. So I'm not sure if the judge moved the one from tomorrow to December or if they're still going to have both. But I'll definitely double check and let you guys know. Any further questions? Why you guys got me here? Said I to you. Oh, you're welcome. You're more than welcome. You guys, thumbs up the video. We've had talked about a lot. We have some more information on this building that we were talking about, but I'll probably do that in another video. It's not very long, but I don't want to have too many topics in one video. Nope, they never caught the third guy. What a um that's all. Okay. Anything else on your mind that you want me to discuss? Some things I may discuss generally if I can predict what some of you guys would ask. Anything else, y'all? Anything else? Thank you guys for joining me. If you have not done so already, please subscribe, please like, and please share. Let everybody know about us. We have a good time over here. We do everything from an intellectual analysis standpoint. Every now and then we have a little intellectual shade, but for the most part, we try to stick to the facts and the law, and we give our opinions. Well, the facts presented, because there are other people's facts most of the time. So you're welcome. You're welcome, Alice. Thank you. And happy birthday to you again. Check out the video. Yes, I did. I did. Thank you. Was he really evicted from the event center? I have not heard that. I haven't heard that. Where'd you hear that from? Did we talk to the lady that owns it? That's not information that I have. Thank you so much, Angela. I appreciate it. Thank you, Raymel. You guys are such a gift to me. So if there's anything you guys want to talk about, maybe perhaps tomorrow or late tonight, you can DM me, or most of you guys have my email address and you email me, and I'm pretty quick on responding to emails because that's how I communicate with everybody, even the court. So I check all my emails. And we can discuss it. You said the streets are talking. I thought he owned the whole block. He was talking about those apartments because they are pretty. Isn't it like 3 buildings or something? You're welcome, and you have a blessed and peaceful and safe evening too. You're welcome. Well, all right, you guys. Well, it was fun chatting with you as always. If you guys haven't done so, please like the video, subscribe, share. And that is our current update. We will keep you abreast of everything that is going on. And maybe the next trial that comes up, if there's a trial that you guys want to follow from beginning to end, we can start following a trial once it comes on. That would be pretty dope for us to be able to, like, from opening to closing, and you guys can come in and out as we're streaming it. The Brooks case basically cross-examined ex-girlfriend. Bye-bye. Thank you. I enjoy you guys as well. I enjoy all your comments. All right, y'all. I'm going to talk to you next time.